Welcome, deep divers. Have you ever stopped to think how, I don't know, a simple local argument over property taxes could, like, completely reshape a country's legal system?
It sounds unlikely, maybe, but that's exactly what happened in the case we're diving into today.
We're talking about Fedsure Life Assurance v. Greater Johannesburg Transitional Metropolitan Council. A bit of a mouthful, but really fascinating.
Absolutely. Think of it as, well, a shortcut to understanding a really key moment in South Africa's legal history, especially post-apartheid. Our mission today, unpack it. Look at the arguments, the court's thinking, and, crucially, its lasting impact.
Yeah, how it changed things. And we're going straight to the horse's mouth for this one, the Constitutional Court's own judgment. That gives us a direct window, right? Exactly, a direct view into the legal nitty-gritty. Okay, so let's set the scene. What kicked this all off?
It started with a pretty hefty increase in property rates. This was back in June 1996, levied by a local council body in Greater Johannesburg.
And some people weren't happy.
10 ratepayers, specifically, challenged it. But here's the thing, it wasn't just about paying more tax, not at all. This whole dispute was deeply tangled up in the history of post-apartheid South Africa.
Right. You can't separate it from that context.
You really can't. South Africa was facing this monumental task, transforming from, well, a system rooted in discrimination to a constitutional democracy. And the inequalities at the local level, they were just incredibly stark.
How so? What did that look like on the ground?
Well, you had the historically white areas, developed infrastructure, high property values, a strong tax base.
Okay.
And then the complete opposite in areas designated black, colored, Indian, chronic underdevelopment, terrible services, practically no rate space to speak of.
The apartheid city, as they called it.
Precisely. Fragmented, divided, yet economically linked in a way that white areas basically benefited from black labor but didn't share the tax income. That was the reality they were trying to fix.
A huge challenge.
Yeah.
So how did the new legal system even begin to tackle that?
The interim constitution, which kicked in around April '94, was the starting point. It aimed squarely at dismantling that old system. Part of that was setting up a whole new local government framework through something called the Local Government Transition Act, the LGTA.
And that act laid out steps for change.
Yeah, it had phases, a pre-interim phase, an interim phase, setting up temporary councils, then more structured transitional ones. Fedsure happened during this transitional period.
Makes sense. And Johannesburg, being the economic hub, must have been a major focus for this transformation.
Absolutely critical. It happened in stages there. First, they set up the central body, the Transitional Metropolitan Council. Let's just call it the TMC.
Okay, the TMC.
Its job was huge, winding down the old segregated local bodies, building new admin capacities, setting service standards, and crucially, making sure all the new local substructures had enough money, especially for, reconstruction and development.
So the TLC was funding these substructures initially.
That's right. Then, later laws kind of tweaked the setup. They gave the TMC power to levy what they called an equitable contribution from the substructures based on their income, and they defined what powers the substructures themselves had.
Right, and this is where we get closer to the actual tax issue in Fedsure, isn't it? This equitable contribution idea.
Exactly. It leads directly to the rates that got challenged. For the 1996-97 financial year, the TMC and its 4 substructures created a combined budget.
A joint effort.
A joint effort, yeah. They agreed on spending together, tried to keep increases modest, and here's the key bit. They applied a uniform property rate across the whole metro area. 6.45 cents in the rand, I think it was.
A uniform rate, but across areas that were anything but uniform historically. That must have had some interesting consequences.
Oh, absolutely. Because the areas were so unequal, that single rate meant some substructures, the historically wealthier ones, ended up with big surpluses.
Okay.
While others, including the central TMC itself and the historically disadvantaged areas, faced deficits.
Ah, I see where this is going.
Right. So the policy was, if you had a surplus, you paid a levy to the TMC. If you had a deficit, you got a subsidy from the TMC, funded by those levies.
So basically moving money from the richer areas to the poorer ones.
Essentially, yes. It was cross-subsidization, plain and simple. A mechanism designed specifically to try and level the playing field, address those historical imbalances, build one city,
Okay, so put yourself in the shoes of a ratepayer in one of those surpluses areas. Your taxes go up, and you see a chunk being sent elsewhere. What was their legal argument against this? Why did they say it was unlawful?
They hit it from 3 main angles. First, they argued the TMC's levy, the money it took from those surplus substructures, was ultra vires,
Ultra vires meaning?
meaning beyond its powers,
Yeah.
acting outside its legal authority. They said, look, this levy isn't an equitable contribution based on gross or rates income like the law actually required.
Right.
They also argued it wasn't strictly necessary for the TMC to do its own job, and it wasn't based on a uniform structure for its area, which the interim constitution mentioned, basically attacking the legal basis for the levy.
Okay, that's a direct challenge to the whole redistribution model.
Yeah.
What was argument number 2?
Second, they went after the local substructure's rate itself, that's 6.45 cents. They argued that was ultra vires too.
Why?
Because, they claimed, its main purpose wasn't just to fund local services in that area, but specifically to raise money to pay the TMC's levy, making the rate itself unlawful in their view.
Got it. So attack the levy, attack the rate used to pay the levy. What was the third point?
The third was about process, procedural irregularities. They said the budgets, both for the local substructure and the TMC, weren't properly considered or approved.
Oh, so?
Specifically, they pointed to rules in the old local government ordinance saying the finance committees were supposed to draw up and present detailed estimates first. They claimed that didn't happen correctly.
Okay, so substantive arguments about powers and a procedural one about how the decisions were made. Quite a broad attack.
Definitely, they were challenging the whole setup.
So the case goes to court. The local high court said no, dismissed the application. The ratepayers appealed to the next level up. The Supreme Court of Appeal, the SCA. But then things took a turn, right?
A big turn. Day one of the appeal hearing, the SCA judges themselves pipe up and say, hang on, do we even have the power, the jurisdiction to hear this case?
Why would they ask that?
Because under the interim constitution, the rules were a bit complex. Matters involving interpreting or enforcing the constitution, especially anything touching on administrative action, were supposed to go exclusively to the constitutional court, the highest court, the CC.
Ah, so the SCA felt this case fell into that constitutional bucket.
Exactly. They looked at the arguments, saw they were all about the powers granted by the Constitution and whether the councils acted constitutionally, and concluded they, the SCA, had no jurisdiction. Even the common law points were tied up with constitutional interpretation. It was a bit of a legal traffic jam.
So the SCA basically had to pass the buck upwards.
Pretty much. They recognized it was a hugely important case for the public, so they referred it directly to the Constitutional Court. They asked the CC two main things.
Which were?
One, were these council resolutions actually consistent with the interim constitution, thinking about them as administrative actions, which everyone had sort of assumed they were up to that point? And two, if they were okay constitutionally, did the SCA still keep any kind of common law power to deal with such issues?
Okay, so the case lands at the Constitutional Court. And this is where things get really interesting conceptually, isn't it? The whole premise shifts.
It really does. The first thing the CC did was question that basic assumption. Were these council decisions, setting rates, imposing levies, actually administrative action under Section 24 of the interim constitution? The government side now started arguing, no, wait, these are legislative actions?
Legislative versus administrative. Why does that distinction matter so much?
It matters hugely because the Constitution had specific rules for administrative action. It had to be lawful, procedurally fair, justifiable. You had a right to reasons. But those rules didn't necessarily apply in the same way to legislative action, like Parliament passing a law.
So how did the court figure out which was which here?
They did a deep dive into how government works. They said, look, there's a difference between what individual officials do, functionaries, maybe that's administrative, and what elected bodies like municipal councils do, especially when they're debating and deciding policy. And the court decided that under the new constitutional setup, these local councils weren't just, rubber stamping things or carrying out orders from above. They were deliberative legislative assemblies in their own right. They had their own constitutional powers to make laws for their areas.
So setting tax rates, deciding budgets, those are core legislative functions.
That's exactly what the court said. These kinds of decisions, especially about raising and spending public money, are inherently legislative. They're political choices. Councilors make them and they answer to the voters for them.
Not just administrative box ticking.
Not at all. So the court's conclusion. Imposing rates, levies, subsidies, these were legislative actions. Therefore, Section 24, the section dealing with fair administrative action, just didn't apply. It didn't fit these kinds of broad policymaking legislative decisions.
Okay, so Section 24 is out. Does that mean the councils could just do anything? Was there no constitutional check on these legislative powers?
Yeah.
That sounds dangerous.
No, absolutely not. And this is maybe the most important principle to come out of Fedsure. The court said even if Section 24 doesn't apply, there's a more fundamental principle baked into the Constitution. Legality.
Legality.
Right.
Part of the rule of law.
Exactly. It's fundamental. What does legality mean for you, the listener? It means all public power, whether it's legislative, like making laws, or executive, like carrying them out, must be exercised lawfully. Power can only be used if the law actually grants that power, and only within the limits of that grant.
So you can't just make it up as you go along.
Precisely. The court said this principle of legality is implicit in the whole constitutional structure. So the old common law idea of ultra vires acting beyond your powers still matters, but now it's grounded in this constitutional principle of legality. Checking if the councils acted lawfully was still a constitutional question for the CC, just not under Section 24.
Okay, that's a really crucial clarification. So with that framework legality, not administrative action,
Yeah.
how did the court rule on the actual challenges? What about that 6.45 cent rate itself?
On the rate, the court was unanimous. They dismissed the challenge.
Why?
Their reasoning was quite practical. They said the local substructure, the EMS, drafted its budget assuming, reasonably and in good faith, that the levy it had to pay to the TMC was valid. Even if, hypothetically, that levy was later found to be unlawful, the rate itself wouldn't automatically become invalid just because it was based on that assumption.
So the initial calculation was reasonable at the time.
Yes, based on a reasonable financial plan. Any surplus or deficit resulting from a later finding about the levy could just be adjusted in the accounts later on. The rate itself stood.
Okay, that makes sense. What about the procedural challenge? The claim that the budgets weren't done properly because the finance committees hadn't presented detailed estimates beforehand.
That was also dismissed, again unanimously. The court found there'd been effective compliance, meaning, yeah, maybe the final printed budget books weren't ready weeks in advance, but detailed estimates were available. They were on computer, accessible to council members through something called the Budget Advisory Committee process. The info was there.
So the substance was there, even if the formality wasn't perfect.
Pretty much. The court interpreted draw up, the estimates to mean have drawn up, as in the information existed and was considered. So substantial compliance was good enough.
Right. Now for the main event, the TMC levy, the compulsory contribution from the richer substructures. This was the really contentious part where the court split.
This was absolutely the crux, yes, and where the judges just couldn't agree. Interestingly, they all agreed on the purpose of the levy. Everyone accepted the goal, fixing past inequalities, upgrading services, aiming for equity was legitimate and necessary.
Okay, so the goal wasn't the issue.
No. The fight was about whether the levy itself actually complied with the specific wording of the law. Remember, the law said it had to be an equitable contribution based on the gross or rates income of the substructure. Did this levy meet that definition?
And that's where they divided.
Yeah.
How did the two sides see it?
Okay, so one group, 4 judges, said no, it didn't comply. They argued the levy wasn't really based on gross or rates income. It wasn't a percentage or a formula applied to that income. It was just whatever was left over, the surplus after all expenses.
A leftover.
Right. And they said interpreting gross or rates income to actually mean net income after expenses was just ignoring the plain words gross or rates. For them, it didn't fit the legal description, so the levy was unlawful. Ultra vires.
Okay, that's one view. What about the other judges?
The other Group 5 judges reached the opposite conclusion. They said, yes, the levy was lawful. They argued based on should be read more broadly. It just means there has to be some relationship or connection, not necessarily a strict mathematical formula.
A looser interpretation.
A more contextual one, maybe. They pointed to the whole one city, one tax base idea, the history. They highlighted the uniform budgeting process that the TMC and all substructures used same methods, same principles applied by that Budget Advisory Committee. And they stressed how interdependent these metropolitan structures were meant to be.
So for them, the levy was connected to the income.
Yes. They said the levy was the surplus, and that surplus clearly came from the gross income, even if you accounted for expenditure. So it was based on it in a meaningful way. They also felt the overall process met the constitutional requirement for action based on a uniform structure.
Wow. 5 judges versus 4. A really narrow split on the most critical issue. What does that mean for the outcome?
It meant there was no majority to overturn the High Court's original decision on the levy. The High Court had found the levy lawful. Since the Constitutional Court was evenly split 5-4 against overturning that, the High Court's decision stood. The appeal against the levy's lawfulness was dismissed.
So the levy remained in place, essentially because the judges couldn't form a majority to strike it down.
Exactly. It really shows how fine the line can be in legal interpretation and how a divided court can lead to a sort of status quo outcome.
Now, Fedsure wasn't just about Johannesburg's taxes. It had this huge ripple effect on the court system itself, didn't it? Connecting to the bigger picture.
Oh, massive. This is another major legacy of the case. The Constitutional Court took the opportunity to address the whole jurisdictional mess under the interim constitution.
The issue the SCA bumped into: who gets to hear constitutional cases?
Precisely. The CC judges unanimously agreed that the setup under the interim constitution, which basically sidelined the SCA from most constitutional matters, was, in their words, unsatisfactory.
Why unsatisfactory?
It caused delays, confusion, parties didn't always know which court to go to, and it meant the SCA, a court with huge experience and expertise, wasn't able to fully contribute to developing constitutional law. It just wasn't efficient or sensible, especially for a new democracy needing legal clarity.
So how do they fix it? What does this mean for you, the listener, if you have a constitutional issue?
They used a provision in the new 1996 Constitution. There was a transitional clause saying old cases should generally be finished under the old rules unless the interests of justice required using the new rules.
And the court said?
The court said it was in the interests of justice to apply the new rules going forward. Specifically, it meant the SCA could now exercise the full constitutional jurisdiction given to it by the 1996 Constitution, even when dealing with cases that started under the interim constitution.
So they basically opened the door for the SCA to hear constitutional matters properly?
Yes. It
Well,
dramatically expanded the SCA's role, made the system more logical, improved access to justice, and allowed the SCA's expertise to be brought to bear. A really pragmatic, important fix for the whole judicial system. It showed the Constitution evolving in real time.
okay, so wrapping this up. Fedsure, quite a journey. It started with local taxes, but touched on the deepest challenges of transforming South Africa.
Absolutely. It forced the courts to grapple with historical inequality, the nature of government power, legislative versus administrative, and that fundamental bedrock principle of legality.
And we saw how even the highest court can be deeply divided on interpreting the law, leading to, well, a compromise outcome on the core issue.
And don't forget the huge impact on court structures, making the whole system work better. It really demonstrates that tension, doesn't it, between central power trying to impose fairness and local realities, and how judges try to navigate that.
It really makes you wonder, doesn't it, how many other seemingly small local disputes, maybe about zoning or licenses, or yes, taxes, are actually hiding these huge foundational legal questions. It's a powerful reminder that law happens everywhere, not just in the highest courts. Thanks for digging deep with us today.